But please the court, my lady and learned assessors, I appear for the state with my colleague, Ms. Johnson.
Mr. Oldwage and I appear on behalf of the accused, and the attorneys Ramsey Webber are also present in court.
Thank you very much.
But please the court, my lady, we are ready to proceed.
Are you ready?
We are ready to
Yes.
proceed.
Just a few housekeeping issues. The proceedings are in English. Fortunately, we have a team of interpreters who will assist us so that every one of us understand what is going on. Secondly, the starting hours is still something that we're going to work on. It's 10 o'clock in the morning. It was supposed to have been 10 in the morning. Unfortunately, there were hiccups. That's why we're only starting now. But we shall sort this out during the course of the day, what hours we will be starting.
As a court pleases.
And the third thing, I'm sitting with assessors, and I would like to swear them in. Please stand up for the record. Please state your full names.
Janet Henson de Toy?
Do you have any objection against taking the oath?
No.
Do you swear that you will, on the evidence placed upon you, give a true verdict upon the issues to be tried? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. Please stand for the oath. State your full names for the record.
Temba Simon Mazibo.
Do you have any objection against taking the oath?
No.
Do you swear that you will, on the evidence placed before you, give a true verdict upon the issues to be tried? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you very much. You may be seated. Yes, Mr. Nell.
Please the court, my lady, would the court prefer that I read out the charges against the accused?
Yes, the accused is English speaking?
Indeed, my lady.
Yes, yes, you may do so.
The first count against the accused, count 1, is one of murder, read with the provisions of section 51(1) of Act 105 of 1997. In that, upon or about 14 February 2013 and at or near 286 Bushvilla Street, Silverwoods Country Estate, Silver Lakes, in the district of Pretoria, the accused did unlawfully and intentionally kill a person, to wit, Reeva Steenkamp, a 29-year-old female.
Yes. That is count 1.
That's count 1.
Yes. Do you understand the charges, Mr. Pistorius?
I do, my lady.
How do you plead?
Not guilty, my lady.
Thank you.
Please the court, my lady, count number 2, contravention of section 127 of the Firearms Control Act, Act number 60 of 2000. In that, the accused is guilty of the offence of contravention, of contravening the provisions of section 127, read with section 1, 103, 121A, section 121, read with schedule 4, and section 151 of the Firearms Control Act 60 of 2000, discharge of a firearm in a build-up area or any public place. My lady, I have to start the proceedings by asking that this charge be amended.
Yes.
There's a typing error.
Yes.
I'll read it. In that, on or upon 30 September 2012, my lady, the indictment reads 2010, and that's just a typing error, as can be seen from the alternative count. There's a reference to 2012.
Yes, so it should be amended to 2010.
30 September 2012, my lady.
12.
Yes, my lady.
That's the first. Oh, yes, I'm looking at the wrong one. That's count number 2.
Indeed, my lady.
Okay, it is amended.
I'll then read it again.
I should have
In
asked
that,
if there are any objections.
There is no objection. Thank
No
you, my
objection.
lady.
Thank you very much.
I'll then
Yes.
read it again, my lady. In that, on or about 30 September 2012, and whilst driving in a vehicle with other passengers on a public road at or near Modderfontein in the district of Kempton Park, the accused did unlawfully discharge a firearm without good reason to do so by firing a shot with his own 9mm pistol through the open sunroof of the car they were travelling in.
How do you understand the charge?
I do, my lady.
How do you plead?
Not guilty, my lady.
Thank you.
Lady count 2 as an alternative, contravention of section 123B of the Firearms Control Act, number 60 of 2000. That the accused is guilty of the offence of contravening the provisions of section 123B, read with sections 1, 103, 121A, section 121, read with schedule 4, and section 151 of the Firearms Control Act 60 of 2000, reckless endangerment. That reads, in that on or about 30 September 2012, an atto near Modderfontein in this district of Kempton Park, the accused in circumstances mentioned in count 2 above discharged a firearm with his 9mm pistol with reckless disregard for the other passengers in the car and or people in the vicinity.
Do you understand the charge that has been read out?
I do, my lady.
How do you plead?
Not guilty, my lady.
Thank you.
This is good, my lady. Count 3. That's a contravention of section 127 of the Firearms Control Act number 60 of 2000. That the accused is guilty of the offence of contravening the provisions of section 127, read with section 1, 103, 121A, section 121, read with schedule 4, and section 151 of the Firearms Control Act 60 of 2000, discharge of a firearm in a build-up area or any public place. The charge reads, my lady, in that during January 2013 and at Tasha's restaurant Melrose Arch in the district of Johannesburg, the accused unlawfully discharged a firearm with a Glock 27 pistol without any good reason to do so. Tasha's restaurant is a public place.
You've heard the charge that was just read out. Do you understand the charge?
I do, my lady.
How do you plead?
Not guilty, my lady.
There's an alternative to count 3, a first alternative, my lady. Contravention of section 123A of the Firearms Control Act number 60 of 2000. That the accused is guilty of the offence of contravening the provisions of section 123A, read with sections 1, 103, 121A, section 121, read with schedule 4, and section 151 of Firearms Control Act 60 of 2000, negligent damage to property. In that, on or about January 2013, an atto near Tasha's restaurant Melrose Arch in the district of Johannesburg, the accused negligently used a firearm with a Glock 27 pistol and caused damage to the floor of the restaurant.
Do you understand the alternative count?
I do, my lady.
How do you plead?
Not guilty, my lady.
Lady, there's a second alternative to count 3. Contravention of section 123B of the Firearms Control Act number 60 of 2000. That the accused is guilty of the offence of contravening the provisions of section 123B, read with sections 1, 103, 121A, section 121, read with schedule 4, and section 151 of the Firearms Control Act 60 of 2000, reckless endangerment. In that, on or about January 2013, an atto near Tasha's restaurant Melrose Arch in the district of Johannesburg, the accused discharged a firearm with a Glock 27 pistol at the table in the restaurant amongst other patrons in a manner likely to endanger the safety of the people at his table and or other patrons and the property of the restaurant. The accused had, in discharging the firearm that was mentioned, shown a reckless disregard for the safety of the patrons or property of the restaurant.
Do you understand the count?
I do, my lady.
How do you plead?
Not guilty, my lady.
Thank you.
My lady, and then finally count 4. Contravention of section 90 of the Firearms Control Act number 60 of 2000. That the accused is guilty of the offence of contravening the provisions of section 90, read with section 1, 103, 117, 121A, section 121, read with the schedule 4 and Firearms Control Act 60 of 2000, and further read with section 250 of the Criminal Procedure Act 51 of 1977, possession of ammunition, my lady. It reads, in that, on or about 16 February 2013, an atto near 286 Bushwillow Street, Silverwoods Country Estate, Silver Lakes, in the district of Pretoria, the accused that unlawfully have in his possession ammunition to wit 38.38 rounds without being the holder of a license in respect of the firearm capable of discharging the ammunition, a permit to possess ammunition, C, a dealer's license, manufacturer's license, gunsmith license, import, export or in transit permit, or a transporter's permit issued in terms of the Act, or D, or is otherwise authorized to do so. Right, that's count 4, and that completes the indictment.
Yes. How do you understand count 4?
I do, my lady.
How do you plead?
Not guilty, my lady.
Not guilty. Mr. Rue, is this in accordance with your instruction?
That is indeed so. Thank you, my lady.
Any explanation of
My
plea?
lady, Mr. Oldwaits will do the read the explanation into the record.
Thank you very much.
My lady, with the court's leave, I propose to hand up 3 original versions of the Section 115 plea explanation,
Yes.
which have been signed, as you will note, in the last page of the document by our client. We'll also favour the State with a copy of this very same document.
Yes, please proceed. Yes, you may
With your
proceed.
ladyship's leave, might I then proceed to read it into the record?
Yes.
I'm indebted. In the High Court of South Africa, Gauteng Division, Pretoria, case number CC 113/13, in the matter between the State and Oscar Carl Pistorius, the accused, explanation of plea in terms of Section 115 of Act 51 of 1977, I, the undersigned Oscar Carl Pistorius, hereby furnish the following explanation of plea with reference to the charges to which I plead not guilty. Add count 1, murder, read with the provisions of Section 51, subsection 1 of Act 105 of 1977. Paragraph 1. In its formulation of this count, the State has contended that I unlawfully and intentionally killed Reeva Steenkamp, hereinafter referred to as Reeva. Paragraph 2. This allegation is denied in the strongest terms. In fact, at the time of the tragic accident which led to Reeva's death, we were in a loving relationship. Paragraph 3. Whilst I admit that I inflicted the fatal gunshot wounds to Reeva, this occurrence was indeed an accident in that I had mistakenly believed that an intruder or intruders had entered my home and posed an imminent threat to Reeva and me. Paragraph 4. In my application for bail, I concisely dealt with the events of 14 February 2013. I am advised that I will have an opportunity to deal with a comprehension version of the events when I testify. For purposes of my plea explanation, I emphasize the following. Paragraph 4.1. During the early hours of the morning, I brought 2 fans in from the balcony. I had shortly before spoken to Reeva, who was in bed beside me. 4.2. Unbeknown to me, Reeva must have gone to the toilet and the bathroom at the time when I brought in the fans, closed the sliding doors and drew the blinds and the curtains. 4.3. I heard the bathroom window sliding open. I believed that an intruder or intruders had entered the bathroom through the bathroom window, which was not fitted with burglar bars. 4.4. I approached the bathroom armed with my firearm so as to defend Reeva and I. At that time, I believe Reeva was still in the bed. 4.5. The discharging of my firearm was precipitated by a noise in the toilet, which I, in my fearful state, knowing that I was on my stumps, unable to run away or properly defend myself physically, believed to be the intruder or intruders coming out of the toilet to attack Reeva and me. Paragraph 5. I respectfully believe that the State has no basis whatsoever for alleging that I wanted to take Reeva's life. I will demonstrate hereunder that notwithstanding the fact that all the objective evidence will corroborate my version of the events, the State has embarked on a strategy to rely on unsubstantiated allegations in an endeavor to prove that I wanted to kill Reeva. Paragraph 6. The strategy was also employed at my bail application. I will hereunder concisely deal with some of the material aspects to support my contention herein. Paragraph 7, at my bail application, the state inter alia contended that I deliberately shot Reeva whilst I was positioned at a distance of about 1.5 meters from the toilet door, and whilst I was standing on my prosthesis. The allegation with reference to 1.5 meters and me wearing my prosthesis was clearly designed to suggest that I had pursued Reeva to the toilet and that I therefore knew that Reeva was in the toilet. Thus, that I did not entertain any fear at a time when it is alleged that I entered the bathroom. Paragraph 8. The state has also, by means of the evidence of the then investigating officer Hilton Botha, sought to rely on a statement by a witness who I am told is a certain Estelle van der Merwe, who claims to have my lady, there may have been an argument between the applicant and the deceased, and the evidence might point in that way, unquote. This witness has since deposed to a further statement, which materially contradicts her first statement. In the further and better particulars, the state disavows reliance on the first statement. The state has also conceded in the further and better particulars that they are not aware of any of the detail regarding, in brackets, the alleged argument, and that it may become clear during the trial. Paragraph 10. Van der Merwe's house is located approximately 105 meters from my bedroom, with my bedroom and bathroom windows facing in the opposite direction to Van der Merwe's house. It would not have been possible for Van der Merwe to have heard anyone talking from my bedroom in their bedroom. The state is furthermore in possession of statements by a number of witnesses, including witnesses resident in either the estate where I reside or in an adjacent estate. None of these witnesses claim to have heard any argument between Reeva and I, nor any woman's voice talking prior to the shooting, notwithstanding the fact that two of the witnesses, open brackets, who live in closer proximity to my house than Van der Merwe, close brackets, were awake at the time when Van der Merwe alleged that she had heard a woman's voice. Paragraph 11. I refer to the above as the state now alleges, in the further particulars provided, that there was, in fact, an argument between Reeva and I, and that I killed Reeva, in quotes, because of the argument, unquote. I am unable to comprehend on what basis the state, brackets at the bail application, close brackets, could only rely on a possibility of an argument between Reeva and I, and now, with even less available evidence, brackets, by disavowing Van der Merwe's first statement, close brackets, allege that there was in fact an argument, and that I shot Reeva, in quotes, because of the argument, unquote. Paragraph 12. I deny this allegation and reiterate that there is no justification, whether legally or factually, for this unfair and incorrect allegation to have been made. The aforesaid allegation is also not supported by any of the statements disclosed to me by the state. Paragraph 13. Furthermore, contrary to what was contended for by the state during the bail application, the state has now conceded that it cannot be contended as a fact that I was about 1.5 meters from the toilet door and that I had my prosthesis attached at the time when I discharged the firearm anymore. Paragraph 14. The unfair approach adopted by the state is further evident from the evidence given by Hilton Botha at the bail application, whose evidence will be demonstrated to have been false in material respects. More particularly, that it was designed to falsely incriminate me on an allegation of premeditated murder. It will also be demonstrated during this trial that whilst Botha was the investigating officer and tasked with preserving the scene, that the scene was contaminated disturbed, and tampered with. This feature of the state's case will be dealt with when Botha, amongst others, gives evidence. Paragraph 15. I have been led to understand that it is unusual to challenge the state's case in my plea explanation to the extent that I do herein. However, I am left with no alternative but to explain my innocence with reference to the allegations leveled against me. The foregoing will be exposed by having regard to the state's intended approach in this trial. This approach is to not only seek to unfairly draw inferences from purported statements of fact, which are not supported by the objective facts, but also, by virtue of the statements disclosed to me by the state, to seek to introduce inadmissible character evidence under the guise that such inadmissible evidence would be admissible similar fact evidence, to demonstrate that there was an alleged nexus between the brackets, inadmissible, close brackets, character evidence and the brackets, non-existing, close brackets, argument which allegedly led to me killing Reeva. Paragraph 16. I am furthermore advised that, as the state is aware of the fact that it has no evidence to prove an alleged argument, and in particular in view of the fact that the state has conceded that it does not know what the features or import of such alleged argument would have been, the only intended purpose of an attempt to introduce inadmissible character evidence would be to engineer and bring about an inadmissible attempted assassination of my character. I am advised that during the conduct of the trial, my legal representatives will object to the introduction of such inadmissible character evidence on the basis as stated above. Paragraph 17. I respectfully state that no truthful evidence can ever be tendered that I fired the shots, and I quote, because of the argument, unquote. I deny this allegation in the strongest terms because there was no argument. Paragraph 18. The allegation that I wanted to shoot, in brackets, or kill, close brackets, Reeva, cannot be further from the truth. Add count 2. Contraventions of section 120, subsection 7 of the Firearms Control Act number 60 of 2000. Alternatively, to count 2, a contravention of section 120, subsection 3, subparagraph B of the Firearms Control Act number 60 of 2000, and paragraph 19. The allegations is formulated in the indictment with reference to this count, and the alternative count thereto are denied. Add count 3. Contravention of section 120, subsection 7 of the Firearms Control Act number 60 of 2000. The first alternative to count 3, contravention of section 120, subsection 3, subparagraph A of the Firearms Control Act number 60 of 2000, as well as the second alternative to count 3, contravention of section 120, subsection 4, subparagraph A of the Firearms Control Act number 60 of 2000, as per paragraph 20. I admit that whilst I was in possession of the firearm as alleged, a shot went off. Save as aforesaid, the remaining allegations as contained in this count are denied. Add count 4. Contravention of section 90 of the Firearms Control Act number 60 of 2000 as contained in paragraph 21. I admit that at all times relevant to this count, I had not been issued with a license to possess .38 caliber rounds of ammunition. Save as aforesaid, the remaining allegations as contained in this count are denied. My lady and learned assessors, that then the plea explanation as envisaged in terms of section 115 of the Criminal Procedure Act, the statement before you with respect has been signed by my client. He will no doubt confirm that in due course on this very day, the 3rd of March 2014. As your ladyship, please.
Thank you very much. Mr. Pistorius, do you confirm the explanation as read out?
I confirm, my lady.
Thank you very much.
My lady, might I then respectfully request that an exhibit number be allocated to the plea explanation?
Yes, what do you suggest we give it?
Maybe AA, my lady. I
AA.
suggest AA.
Yes, this is Exhibit AA. Yes, Mr. Nair.
Lady, as is accustomed in matters, there are certain admissions in terms of Section 220 of the Criminal Procedure Act.
Yes.
My lady, we've prepared files. I beg leave to hand them in, and then I'll read the admissions into the record. My lady, it comprises 2 sets of files.
My lady, I'm so sorry. May the accused be seated?
Yes, yes, please. You
Thank
may
you.
be seated. Is it 2 files?
It's 2 files for each,
For each.
member of the bench.
Thank you.
Lady, I'll take the court through the admissions.
Yes.
The admissions is drafted on a document, and we beg leave to hand that up as Exhibit A. The document containing the admissions would then be marked as Exhibit A, my lady.
yes, this is Exhibit A.
And it reads, admissions under Section 220 of the Criminal Procedure Act, 51 of 77. The accused makes the following admissions as far as count 1 is concerned. The deceased in the matter is Reeva Steenkamp, in a lifetime an adult female. The deceased died on the 14th of February 2013 as a result of multiple gunshot wounds sustained on the same day and at the location described as 286 Bushville Street, Silverwoods Country Estate, Silver Lakes, Pretoria. Number 3, my lady, the gunshot wounds sustained by the deceased were inflicted by the accused. Number 4, the body of the deceased sustained no further injuries from the time of her death until the post-mortem examination was conducted on her body. Number 5, on 14 February 2013, the accused was resident at 286 Bushville Street, Silverwoods Country Estate, Silver Lakes in Pretoria. Number 6, Melanie. On 15 February 2013, Dr. Gert Simon conducted a post-mortem examination on the body of the deceased and correctly recorded his findings on Form GW7-15 with reference to the death register number 0188 of 13, a copy which is annexed here to marked Exhibit B. Lady, in the one file under Exhibit B would then be the post-mortem report.
Yes.
I beg leave that then be marked as Exhibit B.
This is Exhibit B.
As God pleases. 7, the photo album, album 13, images 1103 to 1130, compiled by Warrant Officer van Staden, depicts images of photographs taken during the post-mortem examination, annexed here to as Exhibit C. Lady, in the file it's marked C. I beg leave that it be marked C as Exhibit C.
That's the photo album 13.
That's a photo album of the post-mortem examination,
Yes.
my lady.
This is Exhibit C.
As it pleases. Number 8, the accused formally applied for bail in Pretoria Magistrates Court. A copy of the transcript of the bail proceedings is annexed here to as Exhibit D and is a true reflection of the proceedings and the evidence led. My lady, the second file is the bail application, and that should be marked with I respectfully request as Exhibit D.
This is marked Exhibit D.
As the court pleases. Number 9, the accused was legally represented throughout his bail application by Advocate Drew S.C. and Advocate Aldrich on the instruction of Ramsey Weber attorneys, and all the accused's rights and consequences of his actions in relation to the bail application as provided for in terms of Section 60 of the Criminal Procedure Act, number 51 of 77, we explained to him. He understood, saying, the record is accepted as being admissible as evidence. Number 10, the photo album, album 1, attached here to is E. Lady, it's in the file under E. I beg leave that that then be marked, my lady, as Exhibit E.
This is Exhibit E.
The admission reads further. Photo album 1 attached here to Exhibit E, images 1 to 171, compiled by Warrant Officer van Staden, is comprised of photographs taken at 286 Bushwiller Street, Silverwoods Country Estate, Silver Lakes, Pretoria, provided that it's not admitted that all the photographs in the series depict the scene as it appeared immediately after the shooting incident, as the scene was contaminated and or disturbed and or tampered with. Contamination and or disturbance and or tampering with the scene will be dealt with on behalf of the accused during the cross-examination of Hilton Botha, who was the investigating officer and the person who took charge of the scene. Such contamination and or disturbance and or tampering with the scene will also be demonstrated by having regard to other photographs, including certain photographs in the series number 172 to 914. My lady, in terms of the admission, the photographs are admitted, but not as a true reflection without being tampered with, and that is how it's understood by the state, that it's admitted with that proviso. 11, the photo album 11, attached here to as Annexure F, my lady, if I refer to the file again, under the red F, that photo album, it's indicated photo album 11, if that could be marked as Exhibit F, my lady.
This is Exhibit F.
Will please us. Photo album 11 attached here to Exhibit F, images 915 to 951, compiled by Warrant Officer van Staden, depicts aerial photographs of the accused residential estate, as well as certain distances recorded thereon, between the accused's house and the houses of certain witnesses. It will be, lady, again a typing error, it should read, it will be alleged by the accused that such distances were not measured to the balcony door of the main bedroom of the accused residence. May I respectfully request that the word alleged be entered.
Inserted. Yes. Please proceed.
Pleases. Number 12. Photo album 14 attached here to as Exhibit G, images 1131 to 1141, compiled by Warrant Officer van Staden, depicts photographs taken at Tasha's restaurant in Melrose Arch. My lady, it's filed under G. I respectfully request that it be marked as Exhibit G. My lady.
Yes, this is Exhibit G.
The photo album 15, attached here to as Exhibit H, images 1142 to 1147, compiled by Warrant Officer van Staden, depicts photographs taken at the R25 and M78 roads, Laurie Road, Modderfontein. It's filed in the file as Exhibit H. I respectfully request that it be marked as Exhibit H.
I see H1.
My lady, that's how they did it. It's H and I. I'm not using I.
Oh, I see.
So, my lady, I respectfully request that it be marked as
Yes, this is marked Exhibit H.
H. We will not use I, my lady.
Thank you.
14, the affidavit in terms of Section 2123 of Act 51 of 1977 of Elizabeth Johanna Diaga correctly refers to the records of the weather conditions that prevailed for the Pretoria East area on 14 February 2013 during the hours of 3 and annexed here to marked Exhibit J. Likewise, Ian Glenn van der Nest, with reference to the investigation of the crime, correctly record as follows that no injuries consistent with blunt force trauma were noted at the post-mortem examination, which would have resulted in external blood loss. Lady, there was another paragraph that was deleted, so may I respectfully ask that the word "and" just be deleted.
Yes, what paragraph is this again? 15.
15.1, my lady.
Okay. 15.
15.1, my lady, ends with the word "and." May I respectfully request that the "and" just be deleted.
Thank you. I've done that.
This is 16.
Yes.
The certificate in terms section 2124A and 2128A of the Criminal Procedure Act 51 of 77, as certified by Estelle Mariana Daisel, correctly records a concentration of alcohol in the specimen of blood that was taken from the accused on 14 February to be 0 grams per 100 milliliter. A copy of this certificate is annexed here to mark K. My lady, it's under what we mark J and K. May I respectfully ask that the affidavit of Christel Marianne Duisel be marked as K. It's the last statement under J and K, my lady.
Yes, I found it. This is Exhibit K.
As the court pleases. The analytical report compiled by Dr. P.J. van der Merwe with reference to the result of 2 urine samples obtained from the accused on 14 February 2013 correctly reports that no substances comprised of anabolic steroids, stimulants, narcotics or diuretics could be detected in the sample so analyzed. A copy of this analytical report is annexed here to marked Exhibit L. Lady, we filed it under L. May I request that it be marked L?
Yes, that's Pieter van der Merwe. Is that the one?
Indeed, van der Merwe.
Yes. This is Exhibit L.
The court pleases. As far as count 3 is concerned, it's an admission. A shot went off whilst the firearm was in the possession of the accused. As far as count 4 is concerned, the accused at all times relevant to count 4 had not been issued with a license to possess .38 caliber rounds of ammunition. As the court pleases, that then the admissions in terms of section 2.2.
Thank you very much. Mr. Roux, do you confirm the admissions?
It is indeed confirmed. Thank you, my
Yes.
lady.
Thank you very much.
Are the charges against the accused?
Yes, the accused is English speaking?
Indeed, my lady.
Yes, yes, you may do so.
The first count against the accused, count 1, is one of murder, read with the provisions of section 51(1) of Act 105 of 1997. In that, upon or about 14 February 2013 and at or near 286 Bushvilla Street, Silverwoods Country Estate, Silver Lakes, in the district of Pretoria, the accused had unlawfully and intentionally killed a person, to wit, Reeva Steenkamp, a 29-year-old female.
Yes. That is count 1.
That's count 1.
Yes. Do you understand the charges, Mr. Pistorius?
I do, my lady.
How?
Emilan, staan we nu op. Rising court, toegemaan. But please the court, my lady and learned assessors, I appear for the state with my colleague, Ms. Johnson.
Mr. Oldwage and I appear on behalf of the accused, and the attorneys Ramsey Weber are also present in court.
Thank you very much.
But please the court, my lady, we're ready to proceed.
Are you ready?
We're ready to
Yes.
proceed.
Just a few housekeeping issues. The proceedings are in English. Fortunately, we have a team of interpreters who will assist us. Do you have any objection against taking the oath?
No.
Do you swear that you will, on the evidence placed upon you, give a true verdict upon the issues to be tried? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. Please stand for the oath. State your full names for the record.
Temba Simon Mazigo.
Do you have any objection against taking the oath?
No.
Do you swear that you will, on the evidence placed before you, give a true verdict upon the issues to be tried? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you very much. You may be seated. Yes, Mr. Nell.
Please the court, my lady, would the court prefer that I read?
So that every one of us understand what is going on. Secondly, the starting hours, it's still something that we're going to work on. It's 10 o'clock in the morning. It was supposed to have been 10 in the morning, Unfortunately, there were hiccups. That's why we're only starting now. But we shall sort this out during the course of the day, what hours we will be starting.
As a court pleases.
And the third thing, I'm sitting with assessors, and I would like to swear them in. Please stand up for the record. Please state your full names.
Janet Henson de Toy.